Hello. Hello.
Hello, Nilesh sir. Hello. Nilesh sir, can you unmute yourself?
Can you hear me?
Yes, ma'am. We can hear you.
I can't hear you, Hitesh.
Okay. Hello.
I think Mr. Nilesh Patil has joined.
Yes. Ma'am, am I audible to you? Hello.
Hitesh, you can stop the sharing initially. Don't share.
Yes. Hello, ma'am. Am I
You
audible?
are not audible.
Okay.
Please check it out. There's no voice coming through.
Hello.
One minute, let me check if. No, my side, there's no problem.
You are audible to me, ma'am. Just a minute, ma'am. Hello, Nilesh sir.
Mute.
Oh, you can hear both of us. Very good, thank you. But I am not able to hear Hitesh. I'll check out here.
I think I am mute.
Now speak.
Ma'am, is
Nah.
it audible?
Hello.
No. Hello.
Hello. It is. I can hear you.
Just a minute. माझं ऐकून मी देतो नाही पण मी इथूनच आहे जस्ट चेक ma'am, is it audible right now? Hello, Nilesh sir. Now is it audible?
Yes, you are audible.
Yes.
But hall effect is there. So voice is reverberating.
With echo, I think.
Echo.
Okay. Just a minute.
Hall effect.
तो disconnect करो तिकडे.
Yeah, I can hear you now. Can you hear me?
Yes, ma'am. You are audible clearly.
Yes, you're also audible. Good. I think.
Now is it clear?
Yeah, absolutely. Maybe you should. Thanks, Karan. Maybe you should stop the sharing now and start the sharing afterwards.
Yes, yes. Nilesh sir, please just minimize the slides and then first we will start and then you can start the presentation.
Wait.
Hello.
Yeah, Nilesh, can you also just talk so we are sure we can hear you?
One sec. I can't do.
And if you could stop sharing initially, then we can start sharing later.
Hello, I am Lakshmi Narasimhan from Panchaksha Industries.
Yeah, hello.
Yes, sir. Hello, sir.
Thank you for joining.
Ma'am, I think it is 2:30. So shall we start the session?
Yeah, could Nilesh just say something so we are sure we hear him?
Yes,
Hello,
yes.
hello, Nilesh.
Yes, ma'am.
Yeah, that's fine.
Yes. So, dear participants, thank you so much for joining the session. That is nothing but a workshop, online workshop on intellectual property rights, patents, and design filing, which is jointly organized by Institute of Chemical Technology, NICE Incubation Center, in association with RGNIIPM, that is nothing but Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, Nagpur. So before starting, I will request our Dean Research and Innovation, Professor Padma Devarajan, to open the session and to give the welcome address. So ma'am, over to you, please can go ahead.
Thank you so much, Dr. Hitesh. ICT is really proud to have this session on IPR jointly with the Rajiv Gandhi Institute of Intellectual Property Management. And before I continue, would we request everybody to mute who doesn't have to speak because there's a lot of background noise. A gentle request to everybody, kindly mute. Or maybe Hitesh, you could mute from there. So, welcome to this session on IPR. And why is this important? I think we have a lot of noise coming from Lakshmi Narasimhan. Could we request you to mute, please?
I did it, madam.
Thank you so much. Okay. So we at ICT are indeed very happy to host this workshop jointly with the Rajiv Gandhi Institute of Intellectual Property Management. And basically what we need to address is why is intellectual property becoming so important today? So first, what is intellectual property? It is a right that you have to own your invention, to exploit your invention, to use your invention. And more importantly, you have the right to commercialize your invention. And when you have an invention, you can then go ahead and commercialize it. Now, why is India considering this so very important? Now, if we look at various indices, there is a very important index called the Global Innovation Index. Now, this Global Innovation Index has been very important for every country to grow and to expand their GDP. It is directly linked to GDP. And once again, my request to Lakshmi Narasimhan to kindly mute. Yes. So the Global Innovation Index is a very important index. And if we try to see where India stands, India today is number 40 in the year 2022. In the year 2021, we were number 46. But before that, in the year 2015, we were 81. So this certainly tells us that India is growing quickly on the Global Innovation Index. And one of the indicators of this index is the patent filing that is done. Despite being number 46 on the Global Innovation Index, India leads this index in the lower middle income group. And two specific areas where India is leading as number one is in the finance for startup and finance for commercialization and scale-ups. India is also leading in the number of graduates in science and engineering. So India is poised to grow at a logarithmic rate. And very important is for we academics to understand that we are not just educational institutions doing theoretical learning. We are now being viewed as educational institutions that can contribute to the GDP, that can contribute to innovation, and that can contribute to Atmanirbhar Bharat. The dream of Vision 2024 was $5 trillion US, but because of COVID, India has reached just about 3. But the dream 2047, when India completes 100 years of independence, is US $26 trillion. It's a big dream. And that big dream allows each of us to play a small part. And that is what we are trying to do today in a very small way by joining hands with the RGIIPM to host this seminar on patents, because patents is a very important step to move up the ladder, to move up the innovation ladder, to grow in GDP and to make India Atmanirbhar. So we will be contributing to Atmanirbhar Bharat. So with this opening, let me welcome our speaker, Nilesh Patil. Thank you so much for being here. And very important for us is he's our alumnus also. So we are doubly happy to have Nilesh Patil here introducing all about patents to all of you. And we are also thankful to the Rajiv Gandhi Institute of Intellectual Property Management for considering IICT also as one of the partners to host such seminars and disseminate the importance of IPR across the country. So over to Hitesh.
Thank you so much, ma'am, for your welcome address. So before going ahead, I will give you just a brief introduction about our speaker. Today's speaker is Nilesh S. Patil. He's MTech LLB. He's definitely UDCT alumni. He is alumni of Institute of Chemical Technology, and presently he is working in Indian Patent Office, Mumbai, as an examiner of patents, design, and patent commercialization. He is having more than 6 years of experience. He has handled more than 800 patents. So with this a lot of experience, we seek Nilesh sir more detailed insight about patents, its commercializations, IP, and related laws related to the patents. So with this brief introduction, Nilesh sir, I will request you can go ahead. It's over to you, Nilesh sir. Nilesh sir, you can please unmute and you can share your screen right now to begin with your presentation. Nilesh sir, you are on mute. Please unmute yourself. No.
Thank you very much. I feel very good today that ICT, where it's my alma mater, and I am being called for the interacting with the students, emerging citizens, and all dignitaries. RGNIPM, Rajiv Gandhi National Institute of Intellectual Property Management, and the Controller General of India, Shri Unat Pandit ji, to giving this opportunity to interact with the people on the large scale. So it is very good opportunity for me to present myself on this topic. So I thanks to all of you. So on the day of 15th August 2021, we were entering in the 75th year of independence, Amrit Mahotsav. So on that day, Honorable Controller General had decided, the Minister had decided, and then Honorable General had decided to reach the intellectual property to the 1 million people or students of India. So that was our National Intellectual Property Awareness Mission 1.0. And we have successfully reached the more than 10 lakh students of India within 8 months only. The target was achieved much ahead before the time period. So on the same line, we have now launched NIPAM 2.0, that is to reaching to the 1 crore people, 10 million students of the India, and that to mostly the rural part of the country, and awareing them about the intellectual property rights, including all patent, trademark, design, copyright, all those things. So this is arranged, today's session is arranged under the NIPAM program, NIPAM 2.0. So the Minister and Honorable Controller General has a very prudent vision regarding the development and growth of India. So we are the part of those vision. We are here to proliferate, to progress, to present those vision in our student, and to inculcate that vision in our student, so that, as rightly Madam has said, to have GII, Honorable Prime Minister has said that we are busy with seeing or envisaging the India where we could have rank 25 in 2025. So for that, what we need, what all efforts we are doing here, our party, so that once they are aware, they can easily file they can easily register their intellectual property. And further thing is to harvest the benefit of intellectual property. These are the latter things, but the initial thing is to have awareness, to know about the processes, to how to register your intellectual property, and what are the ways means to have the registration of intellectual property. The basic motto of this NIPAM 2.0 program is to aware more and more students, and once those who are aware, bring them to the next level of advanced training, advanced features, etc. So today's session is regarding to the awareness of the student regarding the intellectual property. So I would like to share my today's presentation. I hope my presentation is visible to one and all. Is it visible, sir?
Yes, Nilesh, sir. Just put it on presentation mode.
Yes. No.
Yes, this is fine.
Okay, thank you. So this is the brief about the NIPAM mission. So as most of the students from ICT, when I was in ICT, I remember that in 2010, we were having the intellectual property course as one of the 6-month course in our syllabus at that time. So ICT was much ahead of time. 12 years ago, they has all those facilities. We already had those facilities in my graduation life also. So just for repetition, for the sake of repetition, I am repeating these types of intellectual property. What are the different types of intellectual property? Patent, design, trademark, geographical indicator, copyright, semiconductor, integrated circuit layout act. These are the basic types of intellectual property. Apart from this, trade secret, which is not recognized in India, that is also international type of property. Development of plant variety, that is also one of the type of intellectual property, but that is cared by the different statute. That's another statutory body. So these are the basic types of intellectual property. So we are using these property daily in our life. Each every day we are having. For example, in this example, you can see that this laptop is made up of which company. You can easily guess from that logo. The logo is a trademark. The LED display is having some technologies to improve the visual presentation of that particular screen. You may remember a few years, 25 years ago, we were having the TVs or screens which cannot even reflect the eyes of the their actor actress properly, but now we can have such a clear screens that who has a very clear ultra clean pictures. So because of this screen technology, the various displays are developed during the. So this is the part of technology. The body or the shape of the laptop is a part of design. The logo, Apple, you said that is a trademark. So user manual, what is given with every electrical appliance, that is a part of copyright. and the various IC integrated circuit that are being built in the technology embedded in the tech, that are part of Semiconductor Act, already covered in the special statute. So this is the simple example put here so that one can correlate that how we are using intellectual property in a day-to-day life. And in the same way, we are using it in other manner also. So simple thing, we go to market and we purchase something, a Parle-G biscuit. So Parle-G is a logo, that is a trademark. We run the day before yesterday, you have the case with the Fabio versus Oreo biscuits, Fabio biscuits of Parle and Oreo biscuits of a company, and they were having the classical case of trademark. I hope some of you aware people might have gone through that case. So what is basically intellectual property and what is basically intellectual property rights? So the important is what is property. In a literal sense, we say that this is my property. So what is a property? It could be a physical property that is tangible or intangible in a sense. That could be a liquid or illiquid property. What is the property? So Stavar Jangam Malmata, like the land, house, this is a property. Trees are also property. So in could sense a liquid property like gold, cash, that is also property. So these are the tangible forms of property. What is intangible form of intelligence? One of the intelligent buddhimatta, that is one of the form of property that you cannot express it, you cannot show it how talented someone is or what the prodigy is, but that is one of property. By just merely sitting in a room, you can narrate a poem, and that could be a fantastic poem. That is a pure property. So narrating the poem, writing a story, that is your property. And this is called as the intellectual property. The property that come out of thinking, that is out of the thinking or the stressing to the brain, utilizing your existing resources, it is called as intellectual property. If you think upon it and you make you write one abhanga or story or some prarthana poem, likewise, then it become a property narrated by you. So it is a matter of copyright. You made a fantastic drawing, and that drawing could be used by someone by as a logo also. That is a trademark. That is your property. You made some classic invention or some incremental invention. Every time would not be classic. It could be incremental invention, but that could be patented in India. I will give many examples in further my series, small session. What could be patented? What cannot be patented? It's not like that one should have a breakthrough invention that only could be patented. Small minuscule invention can also be patented, and these are protected by our law statute also. So one should not be in the impression that we should have the breakthrough invention, otherwise we will not get the patent. And nowadays getting patent is a quite faster and relaxed also. So I hope you are clear with the word intellectual property. What is intellectual property? Now we'll get clearance with the word for rights. When someone has property, someone has to claim it. Unless and until someone claim it, he will not get the right to consume that property. For example, if you have the land, then you will cultivate the land, you will produce some or harvest some grains or vegetables or fruits from them, and then you will sell that fruits, whatsoever fruits, vegetables or grains, and then you will have the claim on that products obtained from that property. So in this way, you are claiming the rights on the product obtained from that property. In this way, here also, whatever the rights you will get in terms of trademark, GI, geographical indicators, or in terms of patents or copyright, those all rights will be protected, and assurance will be given by the President of India on the behalf of, by the Controller General of India on the behalf of President of India. So you have to utilize your rights, you have to protect your rights for the betterment of society. So what is the first step is to protect your rights. Second is to exclude the others. Will you allow to enter someone in your house? It will be trespassing. You will not allow. Means you are first you are protecting your house, and then you are excluding others from your house, and then third one is you are using or consuming your house, your property. You are so likewise in the same manner, the same fashion can be applied to the intellectual property also. So you are creating your intellectual property in the sense of, for example, patents. So you will exclude the others from using that particular technology. And third thing, you are utilizing commercializing your patent so that you will get royalty or you will produce a product from the same patented technology. I hope you can extrapolate the analogy I'm presenting here. I could not be a very good orator or a good speaker, but I think these slides are self-explanatory and this could lead to the better explanation than me. So utilization and commercialization, there could be various aspects for that. Own use, you can use your property for your own purpose. You can license or assign for someone else. You can have various models of commercialization like franchising, merchandise, etc. I hope this part will be covered later or in advanced training manner. What is franchise, what is merchandise, or those who are related to the commercial background, they can easily undercorrelate these parts. What is the purpose of common man in the intellectual property? Usually they have the, like I have 20 patents, I have 5 patents, I have 1 process patent, I have 10 product patents. Like it is a part of pride for common man, or could be for academician purpose, it could be a there for grading purpose, etc. But for what kind of business point of view, it could commercialize and it could impart a good value for the product. For example, nowadays the Shark Tank program is very famous. You might have seen the program, and the sharks are insisting for the thing that do you have patent for the technology? How do you protect the technology? Anyone can easily copy it. So if you have that patented technology, then means exclusively you are the owner for that technology, and you have the right for commercialization of that product. So it is very important for a businessman or companies to claim their commercialization or the proper rights on the patents for commercialization and avoiding others in the legal suits. Brand value, certainly the brands are very important for a businessman. Any business, whomsoever business, the brands are very important. And you know many examples how brand works, and there are many multiple days there are issues regarding the brands, and you can file many you can see the many cases in your regular discussions how they are fighting for the brand, because brand value is very important for your business. I know when you go to the Kalka Devi, you can see the Bhagat Tarachan, new Bhagat Tarachan, old Bhagat Tarachan, and there are multiple names of Bhagat Tarachan. Why it is so like that? So you can understand why what is importance of brand value, and there are many examples for the brand value. You can't whether you know or I can say that this brand Cerelac is registered. Hello. Am I audible? That brand Cerelac is already registered since 1962. So it's a big thing that in 1962 the person who has registered the brand Cerelac, I don't think in 1962 someone has imagined that the baby food brand would be so flourishing or beneficial for him in the 2023, that brand Cerelac would be have the great value. And now we can understand, can anyone sell the sold Cerelac to anyone like this without that brand? So brand value would be created over the period of time. And third one is earn and invest, that is the motto of the businessman. So this is the way of the commercialization. The IP could help in the commercialization of your products. So I will start with the first IP, that is the patent. I hope most of you are knowing the patents in a crude or layman terms, but I will be specific regarding the patent. Patent is a sovereign right granted by the President of India. Here the statement country, the President of India to the company or applicant, specific person, and it's exclusively right for the making, using, exercising, venting, and importing the particular product to only by that person only. So it's an exclusive right, means you have the power to exclude others, and you are the only person who have the right. So this is the simple thing. So in any invention for a limited period of time, exchange for disclosing the patent, it's a very important thing. Please give me a patent, I will not give you. So what is the process for that? Process is simple. You disclose your invention to us in a specific proper manner. You give us information, I will give you rights. If you are not ready to give us information, we will not give you a right. So this is a pro. So you give us information, whether government is satisfied with data information. If it is they are satisfied, they will give you rights. This is the simple thing. So exchange of disclosure, you will be granted a patent. And what is the information here? What is the disclosure? You are disclosing your technical invention, whatever the specification you are, whatever research you have done, that you are exposing to us, exchanging to the government of India. So right to exclude from invention, and owner has a qualified right. This is very important. Qualified right means government of India has all the rights to disqualify you if you are not following the statute. So these are the some famous inventions you can have. Just go to the slide. Just go to the slide. You could have them. So these are the few inventions. Might be patented, might not be patented, but these were the breakthrough inventions in the history of science. So these were the famous inventions from the India. So nano car, this hepatitis C vaccine, Jaipur food. You know that these are how what may effect Jaipur food has made in the on the for the so Divyanga people. So these are the few patented technology, but you can see that how technology comes and vanishes. This is the third technology that where the visa card has been swiped. Very few people has witnessed this technology, and this technology has just just remain only for a few months in the market, and it comes and go up. So there are various TRL level. I hope those who are related with the startup, they know that what are the TRL levels. After so much TRL level and all those study and complications, this technology has passed. I'm talking about the visa card technology, and this technology just vanishing in the 6 months. So you can see the impact of the technology and how it could be vanished so fast. So how much the owner has, the inventor has, or not, that is the different question. So patent application filing. So I will proceed. I hope now you are quite clear with what is patent. So a lot of people, please control. So the patent application filing. Now we see what is patent. Now how to file the process. This is the technical procedure one has to follow to get the patent. So most important is to, there are five six form that one has to file: form 1, form 2, form 3, form 5, and form 18 for the request of examination. So form 1, 2, and form 1, 2, 3, and 5 are for, each form has a very different purpose. So form 1 is of the details of the applicant. Form 2 is the specification. That is what exactly you want to claim, you want from the patent office. And form 3 about what are your inventor, in which country you are going to apply, any foreign filing. And form 5 about the inventorship, how many inventors you persuade for that getting the invention. And form 18 is like request of examination. Whatever application you are filing as, that will be examined in some process manner. So what is the procedure for that? So for example, if you want to go to the darshan for this Sai Baba at Shirdi, and if you are sitting in Mumbai and you go just for the train and you reach the city, will you getting the darshan of Sai Baba? No. First you have to catch the train in Mumbai, and again you have to stand up in the queue at the Sai Baba's temple. Likewise, you have to apply for the patent, and again you have to fill the form 18, that is a request for examination, so that your actual entry for examination will start. Once the application, you have filed the request for examination, examiner of patents and controller will decide on that, and you will get the appropriate response for the office, from the office, and you have to reply for that. Then your application either granted or rejected, that will be based on the merit. So don't believe in a myth that patent filing is a very costly affair. Likewise, that patent filing in a nowadays very simplified. Honorable Prime Minister has insisted on the simplification of the fees, and Honorable Commerce Minister and Controller General has done a lot of work and simplified the fees. You can see in the graph, you see in the PPT or the presentation that for a natural person, startup, small entity or educational institute like ICT or any other universities approved by AICTI or other statute, they just have to fees the form 1 1600 and form 18 4000 rupees. So in a 5600 rupees, one person from educational institute, a startup, natural person or small entity can file a patent. Just imagine, only 5600 rupees. And a company which is established under the statute, company at 2013, that they have to face the total fees around 28,000 for filing the patent. And this fees is applicable for it could be a foreign national or Indian national. So I hope it is quite easier for you to understand it. Filing the filing procedure for online filing, you can see the link where you have to just log in along with your digital signature for final submission. This is the simple requirement. This is as simple as you are logging at some other website. So you can easily log in that and submit your documents. Within 5 to 10 minutes, you can file the patent by just submitting the fees 5600. Your request will be accepted. Your patent will be in the queue for examination on the very next day. If you want to, on the very next day, in the means sense, you have to file the procedure. If you fill the form 9A, it will be published within 15 days and you will be in the queue. If you don't fill the form 9A, you have to wait for the 18 months. That is after the publication of patent. So this is the portal where actually you can file. This is the e-filing portal. It look like this. So earlier we were targeted from many communities that patent is examination is requiring too much time. But nowadays it is very simplified process and fast track process. So we can proudly say that we have granted patent within 6 months also. But someone has to follow the procedure for that, and this is the procedure for expedited examination. Multiple statute amendment and rule amendment has led to the expedited examination. You can go through the slides, and there are various exemptions and criteria has been said. Exemptions has been given to these fellows for the eligible for the expedited examination. For that, you have to pay separate fees. I don't think so. That is very relevant for the at this point of time patent application processing. Simply when you file the application, there are 3 routes to file the application in India. You can directly come to the patent office and submit the application to us. The second way is that you can come via PCT, the Patent Cooperation TT. The PCT is international platform where you can come from other countries to India also. Likewise, you can go from India to other countries also. From you can go from here to Israel, South Africa, China, Australia, etc. Through by the 2 route, convention or PCT. But via PCT, you have to go to the PCT first, and then you can go to the other country. Or convention, you can directly enter to the other country. This is the chart explaining what is exactly the procedure when you file the application to our office. I hope you are gone through this, and this slide will be available to the student afterward by Mr. Hitesh sir. This is our procedure that the patent related to the atomic energy and defense related the policies that we cannot publish them and we cannot grant them. So that's why we have some internal mechanism to study those patents. Hitesh sir, am I so fast? Shall I be quite slow, or am I quite with the speed? Are you grasping me? Any student? Okay, I think I am quite good with the speed. So everyone is with me. So this is the examination procedure. What exactly you expect from us when you submit application to us? आपने हमें एप्लीकेशन दे दिया कि उसके साथ होता क्या है? That is your question. हम आप करते क्या है उसके साथ? So there are the 2 types of examination, formal and technical. This is all done by our examiner. These are the qualified officers. That as I am one of the examiner. After a tough examination, we are coming here. So formal and technical examination. In that formal, we have to find out the legal aspects of your application, whether your attorney is genuine or not, whether your power of attorney has paid specific fees, the stamp duty is correct or not, etc. There are many issues regarding this, Form 13, etc. So this is the formal examination. Form technical examination is the technical aspects evaluation of your patent. Whether whatever application you have made, whatever technology you have developed, whether it is feasible or fitting in the patent statute or not, whether it is as per the patent act or not, that to evaluate or to see it as per the existing set of knowledge or domain, etc. We have to fit in the requirement as per the technical requirements of the statutes. Then we will send the first examination with the gist of objections. Then it is your duty to reply the first examination report. Whatever the objection examiner controller has raised, the report will be sent by the controller only. Whatever the objection raised by the controller, there we have the 2-tier system. After the examination, controller will review or research or rewrite all the report. He has all the powers to overcome my objection, that is examiner objection. So next exam, after you have to reply for the report, whatever you get, you have to write the objection, you have to reply to all the objections. Again, whatever reply you will be given by the applicant, we will consider that in a meticulous manner, and we will offer hearing to you before rejecting or granting any application. We specifically before rejecting any application, we have the very strong internal environment, and we consensus that without hearing, we do not condemn anyone. Without hearing, we do not condemn anyone. We give fair chance to almost everyone regarding to the hearing, so that whatever his concerns, her concerns will be taken care by our officers in a due manner, and due procedure of the law will be followed in the sense that no one feel that he is condemned on So this is the guideline procedure that many of you are the emerging inventor or applicant. So you should know this guideline procedure that on the day you send your application to us, our timeline start from that date. So this is for your information. A very good thing in our act is that the pre-grant opposition and simultaneously post-grant opposition. Many of the statute in the world do not have the pre-grant opposition, but our statute is so prudently devised that it has a pre-grant, post-grant opposition in a very proper manner. There are many sections that part of our statute, but here is not a platform for discuss all those things. Section 84, section 64, 20, section 25, 1B, section 25, 1, section 25, 2. These are the very important statutes of Patent Act. One who is aspiring for the examination of patent agent exam, those has to specifically go through the statute. Exam is coming soon. So second intellectual property is the design. So what the perception everyone bear in his mind about design, that is the same perception here. Design about the aesthetic property of anyone, any object. So how this car look, how this glass look, how the bottle look, how the sofa set looks. This is the aesthetic aspect that is called a design. The shape, configuration, pattern, ornamental, and the composition, lines, colors, the pattern, that is called as a design. I hope everyone is quite clear with the definition of design. So what one perceive, what one eyes visual perception is there. Design is granted for the 10 years and it can be extended to the 15 years. Patent is granted for the 20 years and cannot be extended for 0 years. It can be expanded for 0 years. Patent cannot be extended beyond 20 years. Beyond 20 years. So these are the examples of the designs. Look at the design. These are the various designs. Designs has a very unique importance in the diamond industry, jewelry industry also. So these are the sets. You can see the various types of design. The saucer and the cup and the kettle could have unique designs also. This jewelry and diamond bullion industry has a very great importance of the design. This is the procedure for filing the design. Now electronic filing is allowable. You can file any design application from anywhere from India. No need to come here also. You can file electronically for the design. So e-filing is allowed for the design. So we have the 4 patent offices and 1 national institute at training institute at Nagpur, and the one more, that is the 5th trademark office at Ahmedabad. So design, major office for design is the Kolkata. All applications are processed in the Kolkata. So this is the fees for design design application, that is the 1,000 rupees for the small entity and 4,000 rupees for the legal entity, that is the any firm law, any firm established by law or company established by law. So this is the technical procedure. You can just go for your examination purpose, so you can see it. So you can have a unique perspective for this design. Look at this design, how uniquely drafted, and you can see that ये kettle हमने कभी पहले नहीं देखा था, ऐसा kettle like design. Like you may feel like that. So this is a teapot having such a unique design, and this design has been granted. Once we have granted your design, you will get a certificate like this from the office. Look at the certificate. Like it has been mentioned that Government of India Patent Office certificate for registration of design. Similarly, certificate registration of patent, unique number, etc. All those things. And on the last, there will be a signature of the Controller General of Patent Design and Trademark. That is, nowadays he is a Sri Honorable Unat Panditji. His signature will be there. So these are the various examples of design you can see, and this way we are going to publish your exam, your whatever application. This is our journal. This is the image catch from the journal. Their design number, class number, details of the inventor, etc., and small description about your product. Similarly, every IP is published. Like patents are also published, trademark is also published. And they are published only for the purpose that people should know what exactly is happening in the field. So you can see here the designs are registered for 10 years and can be extended further. So next intellectual property is the trademark. So next intellectual property is trademark. 1 second. So I hope you have gone through various trademarks and you know various trademark. Trademark is any word, symbol, name, device, combination of meaning. It could be a color, it could be a smell also, but in India, smell is not recognized as a trademark still. but smell also one of the component of the trademark. You might have the glittery pen with a specific fragrance, and that could be a trademark of any company. I hope you might have those pens from the France, etc. What is the importance of the trademark? Trademark is a monopoly over the class of the goods and services. So you know them by their services. When I say that I am affording, I am getting services from particular company. That do you know that they have the world class service likewise? So the product is world class product. When I say I have the diamond from the Titan, so you know that the diamonds from the Titan are the authentic, and that is one of the best diamond in the world are supplied, authentic diamonds supplied by the Titan. So the Titan word itself is a brand. If you say I'm working in the Infosys, I'm part, I am aimed at it. So why you are thinking so that because there are the brands established over the years. Similarly, working with any government or international bodies is also brand for any person. These are the few examples of trademark. I hope most of you are knowing all those things. Whenever you watch any Hollywood movies, you can see this Columbia like symbol or Adidas or Google. These are all the trademark, like your ICT logo or your university ICT logo. These all are the trademarks. Mumbai University logo or Raj Mudra itself is a trademark for government of India. But we cannot reduce its status to the trademark, but it is recognition identification for others. What are the characteristics of the good trademark? Distinctiveness hona chahiye. It should be inherent and acquired. It should be honestly adopted. It should not be with a dubious mindset, derived from the dubious mindset. There should be no frivolous or ulterior motives to try to make a trademark. I hope those are related with the pharma industries. Them are knowing with the how frivolous brands are introduced in the market with the deceptive or the copying or the spurious trademarks. How to indicate your trademarks, that is the method. I hope you are watching this, and this is very simple thing. How to protect your trademark? Protection of trademark is an optional thing. Many companies in the world, they have not applied for the trademark, but still their reputation is intact. So if you want to register your trademark, then there is procedure for that. You can register at the national, regional, international level also. So at regional level, we are not following any regional level. European Union, they are following, or the African Union, they are following the regional level, but we are the national level and international level. So initial registration is for 10 years, and further it can be renewed for any time of time, any period of time, indefinitely. But you just have to pay renewal fees for that, pay for the fees for that. So we have the Statute Trademark Act 1999 and the rules in 2017. We are governing all those things as per these rules. So copyright is a very interesting thing. Copyright, most of the people are associated with the copyright and books. Every day we are reading a lot of books, reading material, watching movies and videos. All those things are the part of the copyright. So copyright is an automatic right. Whether you have applied for the copyright or not, it's a different story. But when you shoot a video, you catch the photo, you automatically get the right of that things. So copyright has the three things to be considered here. That is the creativity, originality, and fixation. So all these things are under the. I hope you all are quite aware with the software like ChatGPT, etc. And I can, those who are prudent, they can understand very easily all those three things, how they are challenged by their software like ChatGPT. Can anyone respond me? I am talking in a relevant manner or not? At least someone are getting these points. I hope this session is arranged for the students, and I hope students should interact. Thank you. Features of the Copyright Act. Provisions related to the Copyright Office and the registration of office. These are the features where you can apply. First is to apply the new license, and you can use your copyright for further. What are the different types? What are the copyright is a bundle of rights. I mean, what exactly the rights are there? Literally work, artistic work, dramatic work, musical work, sound recording work, cinematographic work. Each and every term here mentioned it's a vast arena. They have their own issues, they have their own contents, and this is a rich area. Artistic work itself is a rich area, vast arena where a lot of issues are involved in artistic work. But all these six events can be considered under for a copyright act. Who all are the authors of the work? So this is the simple question. If I ask you who has the rights of the song, any song, so your answer should be the lyricist. Lyricist has the most right on the song because he is a gitkar of that git. He has written the git. Then the musician has the right, music composer, who has the right for music. One who perform on that song, that has another ancillary rights. One who sing the song, that also has the right. So one song has many multiple copyrights. Now you can imagine lyricist has another right, singer has another, performer artist has another, music composer has another, and one who sponsored for all those things, that is the producer, has another right, and director who is directing all those people has another right. So in a single song or a single movie, multiple person could hold multiple copyrights. And apart from this, broadcasting rights are different rights. So copyright, there are two issues associated with the copyright: economic rights and moral rights. Our professors write a book after a lot of dedications, efforts, and attempts, and multiple proofreading, etc. And students simply go and copy. You think so? We are doing morally good thing. एक काफी महंगी किताब है इलेक्ट्रिकल इंजीनियरिंग, क्या आप उसको कॉपी करके लेके आते हो? जो राइटर ने इतना मेहनत करके किताब लिखी थी उसको कुछ नहीं मिलता है क्योंकि आपने उसको कॉपी कर लिया. Is it good thing or bad thing? And similar things are happening with the other arena also. Then should it happen or not to happen? So this is the part of moral things, moral issues, whether one should allow such things or not. And the second is the economic aspects of the author. One who written the very good book, for example, any good book you consider like the Game of Thrones or other book or Chetan Bhagat or any writer you are considering. Shall we give them the due remuneration for their books or not? Whatever the efforts they have done, videos for them, or one who made a very good video, shoot very good video, and we're just copying that video and making YouTuber a very famous YouTuber, and you are earning from YouTube, etc. And you are not providing financial assistance to that person. Likewise, it happens in the case of that Kacha Badam song. I hope you know that. So shall they given a lot of money to the Kacha Badam original singer or the lyricist? You know the answers. And here the economic rights are involved in the copyright. Scope of economic right: reproduction right, distribution right, right to create derivative right, broadcasting, communication with people, right to public performance. These are the multiple issues, and these are issues in the in every associate copyright. These are issues associated with the multiple copyrights. Almost film industry से related सारे लोगों के पास ये सारी issues चलती रहती है, and where copyright safety is very important. I hope those who are thinking to practice in this area of the law, they should have the clear understanding and even in fact prudent vision to prosecute their cases in this field. Right against distortion of integrity. These are the moral right: distortion and the right of recognition. कई लोग copy material copy कर लेते हैं, and they are not giving the due respect to the even the original author also. They are copying from their website and they are not mentioning their name. I got the resource. So in the Marathi we say that Saujanya, from, courtesy. We are not using those words. And these things are actually distorting the environment of creativity. So it is very important to give the due diligence or due respect to the or courtesy to the original creator. These are the various terms of where copyright can be protected. 50 years, 26. In case of book writer, things the age of the book, the life of the writer, and the plus 60 years. There are various criteria for that. Like in a patent, this is plain criteria 20. Design plain criteria 10 years. Here is not plain criteria. Here is multiple criteria. So this is the application procedure. This is the procedural aspect, you can get it from Ithesar also, so that you have greater clarity. So you can see in this slide, filing copyright or application for copyright is so simple and very economical economical event. Just 500 rupees for getting a copyright. So if one is, you are making an impression like that, filing a copyright is a very costly affair, then you can imagine what he exactly doing, he or she exactly. They are actually misleading the people. Examination procedure not needed at this level. This is one of the statute that Semiconductor Integrated Circuit Layout Design Act 2000. This act is very prudently devised to protect the semiconductors integrated circuit in our country. But I think this is not the platform, or you are not the audience suitable for this act at this moment. But this is the statute, and this is the part of intellectual property. This is the most important aspect of the integrated intellectual property, geographical indication, Bhaugolik Nirdeshank, and this is the grass-rooted, deep-rooted, and related to the culture ethos of India. So this is the one of the most impactful aspect of the GI, but the type of the GI, that is the GI, geographical indicator. And these are the few examples of the geographical indicator. You can see here. I hope you each and everyone must have seen out of these 12 icons, 14 icons, at least 5-6 icon in your life. Darjeeling tea, Makrana marble, Boglivina, Madurai Malli. And likewise, many, there are 439 GIs approved by Government of India. And recently, we have given the GI to the Assamese government also. Nilgiri tea. There are multiple GI given by the Government of India. Maharashtra also has huge, not only Maharashtra, many states, but Maharashtra has huge tradition of getting the GI. I will show the India map also where which state has a lot of GIs. You can see the Madhya Pradesh, Rajasthan, how the painting. We basically classify GI into agriculture GI and non-agriculture GI. So you can see the Kathputulis from Rajasthan, how beautifully they are carved. And this Warli painting from the Palghar Thane district. Most of you have tasted the Magai Pan at our circle. Many mangoes has been recognized by Government of India. Many mangoes. This Shahi Lychee from Bihar. So from last 20-23 minutes, you are saying that almost is existing every IP is almost everywhere. So we are associated with the IP, and we are living with the IP, and without IP we cannot live. So it is our duty to aware the people about it and to promote the creator of IP in an ethical, lawful manner. So this is the genuine attempt to aware you all about the types of IPs and how you can proceed for the actual filing of IPs. So the Government of India, the Honorable Ministry of Commerce and the Ministry of Commerce and Industries, Honorable Controller General of India, Patent, Trademark Design and Trademark Copyrights, and GI also. The office, they have adopted a very good platform and offices. So we have 4 patent offices, 5 trademark offices, 1 national institute, where young graduates like you can enter. And you have the scope for that. I have already written here. So one more career opportunity could be advisor. If you are a senior veteran scientist, you could be advisor at Controller General Office. So for better contact and further training, you may up to the Rajiv Gandhi National Institute of Training at Nagpur, and you may visit where specific courses regarding the specific intellectual property are carried out. So I hope you are quite clear with this thing. Thank you. Sir, you are not audible.
Hello.
Now you are audible.
Thank you so much, Nilesh sir, having very informative session on pattern design, IP, and very detailed and deep insight about the awareness of intellectual property and how to protect the intellectual property. And definitely it is really helpful for all attendees and our students also. So definitely, so thank you so much for this lecture, and thank you so much for your time also. So only we can take a few questions. If audience are having some questions, then they can raise their hands and we can admit them for questions. So please raise the hands and they can go ahead for question answers. Yes, Madhur, you can unmute yourself.
Yeah, hello. Can you hear me?
Yes, ma'am, please.
Yeah, so a very nice session. Just wanted to know, you just spoke about the various GI, and then you said that they have segregated agricultural GI and non-agricultural GI. But then, like as a state or as a particular region, if someone wants to apply for a particular geographic indication, then what is the process? As in, is it does it happen through the local government?
No,
I mean, is that
ma'am.
state government?
Understood, ma'am. Your question is good. Ma'am, that agriculture and non-agriculture GI, that is just for our internal classification. We are not classifying on any basis. So for easy understanding, that is for those of, like you can say the barley pending. Does it have relevance with the agriculture? I don't think it is barely from the intellect of the person. So this just for the sake of classification. There is no such classification in any statute like agriculture and non-agriculture. But certainly for administrative purpose, we have.
I think there is some lag, maybe because of
Bodies, their own members or own local bodies to the government of India so that they can get the GI. For example, the tribal communities from the Assam, how they can write application in English. If even they write in English, really that English could be perceivable by a person sitting in Delhi or somewhere else. Whatever has been written, that could be really happening there. So it's quite complicated. So they have given right to their some IP professors, IP chairs that they can represent the region and they can put forward their case so that it could be easily facilitated. So definitely some state governments have their own measures, but final right to grant the GI is with the central government, that to the Honorable Controller General only. I hope you are quite satisfied with my answer.
Yes. Thank you, Nilesh. Siddharth, can you please unmute and go ahead?
Hello, sir. It was a great session. I had one doubt that you mentioned that you can get patent for scientific work and copyright for artistic ones. But what if some work is in between these two, like we are publishing some artistic communication in a magazine, like to elaborate certain concept to people. So is it possible that to put copyright on that, like for scientific communication?
Yes, you can have copyright for such a work also. Copyright, getting copyright for any literary work, any writing, any story, any work is easier and it's simplified process. For if you're asking for the patent for the same thing, then it's not a vice versa. First thing, whatever you are told, right, the communication material for proliferating the science, that comes purely under the copyright and not the part of the patent.
Okay, great. Thank you. Is there any questions? Last two.
Yes, sir. One question from the chat box. I can see that. Is it so? I will sumo to pursue for that question. Is it possible?
Yes, sir.
To
You can go.
Is it possible to have copyright on the artistic comic spreading awareness topic like scientific communication? So I just tried to answer for that. So how to prepare government jobs? I am pharma background, so I have mentioned for that for government. So my office is not hiring the pharmaceutical people till now. For future, it may opt for that. And for other offices, you may search from other various sites. One is asking for, can you copyright your PPT presentation? Yes, definitely you can copyright your any presentation, including PPT, poster, or your presentation or your post banner you are presenting in your college auditorium, etc. All those things you can get a copyright for that. But certainly you have to apply for a copyright, and you will get the copyright afterward. Even the same thing that you do not apply for that copyright, that material is yours only, but you don't have power to sue them unless and until you have the formal authority from the office. Means what? इसका मतलब ये होता है कि आपके पास उसका कॉपीराइट है, and despite that you are not sir, I'm in session, I will call you within 5 minutes. Within 5 minutes. So इसका मतलब ये होता है कि आपके पास कॉपीराइट है, but that is not approved by the office, and someone is copying your data, material, etc. Then how will you stop him? How will you stop that infringement? And for that you need some documents from the office. Of course, you can go to the course and you can produce the evidence, but what is the evidence for that? Means मुझे बताइए, आपने hello, am I audible? आपने एक पोएम लिखा, आपने काफी अच्छा पोएम लिखा और आपने वो पोएम आपके कॉलेज गैदरिंग में प्रेजेंट कर दिया सबके सामने, और वहां पे मानो 100 लोग प्रेजेंट थे, उसने पोएम सुना, 100 में से 20 लोगों ने क्या किया, आपका पोएम कॉपी कर लिया, कॉपी इन द सेंस ऑडिबली साउंड कॉपी कर लिया, फिर घर पे जाके उसने अच्छे हैंडराइटिंग में वो पोएम लिखा और वो उसने फोटो खींचा और वो यूट्यूब नेट पे पब्लिश कर दिया बाय हिज नेम, नीचे खुद का नाम डाल दिया, और वो जो इमेज थी जो इंटरनेट पे थी वो काफी वायरल हो गई। अभी वो सब बोल रहे हैं कि ये पोएम तो एक मतलब मेरी है, नॉट यू। तो व्हाट इज द सॉल्यूशन फॉर दैट? वो तो पोएम मेरी हो गई जो कि आपने लिखी थी, आपने गाई थी सबसे पहले, एंड नाउ हाउ विल यू प्रूव दैट? So that's why you need some documentary evidence for your own creativity works.
Okay, Nilesh sir, just one question from my side. What we are doing, the students, they are preparing their presentation by extracting some data from the literature or some research article also. So can we take that presentation as a copyright in which the data which is collected from different sources, maybe from book or maybe from research article also?
The simple provision in the Copyright Act is that you should have the analytical ability. Your data should present the analysis of the existing data. If you are just collating the data from here, there, you are taking chart from there, you are taking the pie chart from that particular, you are taking material from the Economic Survey of India, the poverty has been reducing, and you are not presenting your own analysis. Now you are just collating the data, and there is no analysis, no contribution from your side except collating the data. Then you cannot have the copyright. Technically, in the court, you cannot claim for that. You may get the copyright, but when the matter goes to the arbitration, matter goes to the prosecution, at that time you will be in the trouble. Court will ask you, what is your contribution in it? Then what will you say? Collating data is not a contribution, but definitely if you have produced some extrapolating analysis or extrapolation from that data, then you can get copyright. Further, you have to mention the courtesy from that particular reference from some books.
Okay. It means if suppose someone have copied some image or pie chart from some research article,
they have to do the due diligence, due right for them. Courtesy लिखो ना नीचे कि सौजन्य यहाँ से लिया था, लिखो।
Okay. That's it.
The most important thing in IP is to get the respect. You should first do the respect. आपने दूसरों को भी respect देनी चाहिए कि मैंने वहाँ से लिया था. Yes, likewise.
Definitely, we have to provide the credit to the main author who has created that data particularly.
Yes.
Okay. That's fine. I hope right now there is no question from audience. So Nilesh sir, once again, thank you so much for your valuable time, and definitely we will ask you for some other session that will be in more detail apart from this level, and definitely you will not deny us to organize your next session. So thank you so much. Thank you so much once again to your patent office of Mumbai also and for you also. Okay. Thank you so much.
Thank you. Thank you, Hitesh sir. Thank you, ICT,
So-
and thank you, RJ and IPM. And
Yes,
I
thank-
will be there for in the advanced session also.
Yes, definitely.
Thank you.
Okay, so we are concluding the session right now. So participants, you can leave right now. Only those participants, those who have attended the sessions, we can give the certificates to the attendee only. So we have the record of attendance. So accordingly, we can provide the certificate. You can get your certificate through an email only. Okay, so thank you so much, Nilesh sir. I am closing the meeting right now.